Parliament has welcomed the Western Cape High Court's dismissal of the Public Protector Busisiwe Mkhwebane's application to declare parliamentary rules on the removal of heads of Chapter 9 institutions unconstitutional. National Assembly Speaker Thandi Modise, however, says she will seek legal advice on how to proceed with the investigation into Mkhwebane's fitness to hold office. The ruling came as the Parliamentary Committee conducting an inquiry into Mkhwebane's fitness to hold office adopted its work plan and timeline on the Section 194 process as it approaches the preliminary inquiry. Qubudile Dyantyi is the chairperson of that committee, and he joins us now for more into this. It's so good to have you. Thanks very, very much for joining us.
Good morning, Leanne and your Morning Live team and all your Morning Live followers.
So yesterday was the second meeting by the committee following last week's meeting. What were the deliberations on?
Yesterday was a second meeting of our committee meeting since the election of the chair last week. And basically yesterday constituted what we call the pre-hearing process, the setup process. So yesterday we were meeting to deliberate on the terms of reference, our own work plan, call it a roadmap between when we start and when we end the process. And as you would appreciate, Leanne, this is virgin territory. And in any virgin territory, there are two things that you've got to do and do them well. You've got to define your entry point into a place that you don't know. But secondly, you must define how you exit and get out of that. And so what we're doing yesterday was to say, this is how our work is cut out. This is what is going to bind us in terms of the rules of the process. And so members of the committee collectively deliberated on all of those issues. And we're hoping to finalize that plan next week, Wednesday. And basically that plan, as you would have heard, gives us a timeline of between 3 to 6 months. We really want to finish our work in 6 months' time, or even less than that, if we're able to just have a very tight process, a very focused process, and not being deviated by any other issues.
So the Public Protector has unsuccessfully sought to interdict the process, raising arguments of its constitutionality, saying that Parliament didn't have rules to remove a Public Protector before. But the rules were drafted for the purpose of removing specifically her from office. Is there a clear provision in the Constitution to serve as a blueprint?
Very much so, Leanne. The Constitution in Section 194 provides grounds for removal for all Chapter 9 institutions, not just the Public Protector. It will be the Public Protector, the Auditor General, all other commissions that we have, whether it's the IEC, the South African Human Rights Commission. So Section 194 provides 3 grounds for removal from office. And those grounds are the grounds of incapacity, incompetence, and as well as misconduct. That's a constitutional matter. It's there in the Constitution. And so, but what is in the Constitution does not define the operational matters as to how you regulate that. So we have to create new rules in order to define what we mean by incapacity, by incompetence, as well as misconduct. Hence, we're calling this a virgin territory. These are new rules, not necessarily for the Public Protector. It so happened that the Public Protector will be the first of those institutions that would have to come through this particular process. So the rule-making process was itself a very good process, because in those rules, Leanne, we raised the bar. And so, for example, on both incompetence and misconduct, we raised the bar, for example, in terms of incompetence, to say we define incompetence as this demonstrated, sustained kind of practice. So it's not a once-off thing. So we made it very, very high and very tight in that regard.
we have the likes of opposition leaders, Julius Malema, for instance, asking whether it would be correct to continue with this process when there is a legal process in place. I mean, as we know, the Public Protector's interdict was unsuccessful, and yesterday the Cape High Court, in the Western Cape High Court, dismissed Mkhwebane's application to have the rules nullified. Are there anything other hanging around related to legal issues that are outstanding at the moment?
Yes or no, Leanne. In this sense, so the Public Protector would have sought relief in two parts. The first part was, as you said, Part A, which was the interdict, and yesterday was the judgment on Part B. And in Part B, the Public Protector had 12 prayers that she wanted relief on. She wanted the court to assist her. And the court, out of those 12 areas, then said in 2 areas, for example, that her prayers, her application only succeed in as far as the issue of legal representation. In other words, that Parliament or National Assembly must allow legal representation to participate, because in the rules would have said the legal representation would not participate but would advise the Public Protector. So that's the amendment the court is asking us to do, and as well as the issue of reference to a judge. So out of 12 points or prayers she made, she only was able to get some form of relief in 2 of those. And though both those 2, hence I'm saying we might pause here and there, because on the legal representation, we're not yet there. The legal representation will come in when we start the actual hearing. As we have started last week and yesterday, and as I said to you, it's a pre-hearing process, a setup process. So it's easy to remedy that defect even before we get into the heat of the process. And I think the Speaker would have spoken about us wanting to be guided legally on this issue of reference to a judge and so on. So when you look at it in a whole picture, we respect the fact that she took this to court. We respect her own way of wanting clarity on all of these issues. But yesterday we're planning how we'll proceed with this. We are going to be guided, of course, by that legal advice. But as things stand, we welcome the court judgment.
Well, I mean, you know, Mkhwebane's counsel have certainly argued against this, and we know this, and we've heard this, and some of the words that they've used is saying that the process has been irrational, it's been unfair, it's been unconstitutional. When Modise approved the DA's motion for an inquiry into her fitness to hold office without informing her or even affording her an opportunity to make representations in January 2020. So my question to you is, how is the committee going to ensure that this is actually a fair process?
We started immediately as I got elected. My opening remarks were focused on what you would call the golden rules of fairness, of rationality, of Audi, as well as issues of being persuaded by facts and evidence and not just dealing with hearsay. So there's a serious commitment from the side of the institution, the National Assembly, as well as represented by this committee that I lead, that in fact part of our program, Leanne, says, and that's why we were stretching this to 6 months. We're stretching this to 6 months purely on the basis of trying to achieve fairness in each and every step of the process. So when we would have done our first draft report, we were saying we are going to give her an opportunity for 30 days to read and comment on that report. before we finalize the report. So we have designed a very tight process, but also a process that is punctuated by all of those points of rationality, fairness, audi, and so on.
Yeah, yeah. One of the things that came out in the second part of yesterday's judgment basically ruled that rules be amended to allow a Chapter 9 head to have legal representation. Can we see delays resulting in this ruling?
As I indicated on that particular issue, it will be very much easier for us to deal with that, because we have not even, as I said, we have not started with the hearing, because that would apply when the hearing begins. But the turnaround time for us to attend to that defect of legal representation should really not be a problem. And what it means, Leanne, for us is that if yesterday in our committee meeting, we identified 12 milestones, with the court's judgment yesterday, it says you've got an additional milestone that you need to add, which would be about 13 milestones. So we are incorporating the issues from the court judgment as part of the process. So in a way, you might have a little bit of a more prolonged than we would have anticipated.
Okay.
But we already have a lot of thought in terms of how we manage the process, and in what we call a risk page. We have already identified what would be the risk of this process, and we develop mitigating measures for those particular risks.
Okay.
So that we are proactive in driving the process.
So yesterday's meeting also established that this is not, and this is very, very important, it is not a judicial process to determine whether Mkhwebane, the public protector, is guilty or innocent, but it's an oversight process to establish the grounds on whether she should be removed. It sounds pretty technical, to be honest with you. I mean, what is the difference? I suppose maybe by the time this ends, her time as public protector will actually be up.
Well, I wouldn't speak about out or in, Leanne, but I can say that it is an oversight process. We are members of parliament. We have a constitutional duty as members of parliament. Hence, we are saying it is not a judicial, it's not inquisitorial, it's not adversarial. It is part of our mandate that we must play. And so, even when we deal with the format, we're saying this process, unlike a process, as you would know, in the State Capture Commission, that is led by a judge, this process is going to be led by members. Yes, we'll get support from both internal and external expertise, but we cannot source out our mandate and duties as members of parliament. We've got to lead the process. What support we need, this is what we are putting all together, so that at the end of the day, we must be able to say as members of parliament, we played our role, we committed ourselves to this oath of office that we took, and even in this probe, in this hearing, we did not just ask somebody else to do this on our behalf.
Very quickly, in terms of collecting evidence, what will be the other means? Since we didn't hear that the committee said that there shouldn't be an over-reliance on the panel report findings, but the determination should be made based on this process. So how is this going to work?
Well, in terms of that, obviously, our starting point is the panel report. The panel report is evidence. Yes, we're saying we're not rubber stamping that. There can't be any over-reliance to that. But we also, like any other parliamentary committee, have the means and powers to subpoena witnesses, but also to invite any other evidence as long as it is relevant and is limited to the motion that we have. I mean, to that extent, so if we would have a witness, we also have the powers to recall that witness when we think that something else needs to come out of that process. So there are powers, that we have as a parliamentary committee to seek and to get more evidence than what is in front of us. But we do so that we don't operate like a vacuum cleaner, just being all over the place. we are directed in terms of it has to be evidence relevant to this fact-finding mission that we're doing.
An outcome will be based on a majority vote of at least 2/3, but the committee said it might also consider public participation, including some oral submissions. So to what extent will public participation actually influence this process, notwithstanding that the final outcome lies with Parliament, obviously?
It certainly would. As you know, all our proceedings in Parliament are open to public, and what we also want to make this process speak to that, and in terms of the witnesses, for example, we want to continue as part of this fairness and rationality process that whatever witness we identify, the criteria we use, we want that to be balanced. You would want to have witnesses that come in front of you and say, we support this for these reasons and these reasons. You want to have a witness that says, we're not in support of this, but these are the reasons. And so those things are going to influence the outcome. The outcome is going to be less just about the numbers. Yes, there's a standard about the 2/3. That 2/3 is only invoked when NA has to remove the public protector. But the outcome, the findings that we're going to present to the National Assembly with reasons that we must provide have to be findings that are influenced by evidence, by facts. As I indicated when I got elected, that I did not come into this process with the ANC saying to you, this is what you must do. The ANC said, follow due process, stay on facts, focus on evidence. Okay. And so even in the committee, that process is not going to be directed because ANC members are 19 and others are less than that. Yeah. ANC members or all other members of the committees are going to focus on facts. And I would want to direct that from the chair.
All right. Just as we wrap quickly, your draft program timeline ends in January next year, when the committee will be tabling its report before the National Assembly. Is that a hint of when you'll be wrapping up that process as well?
That's the end point of our plan in terms of the 6 months. Yeah. With yesterday's court process, we hope that we can still manage to get to that end point, but the end point was planned in such a way that we could easily do it even within that 6 months. Good. So we're going to really try and stay focused so that we don't have a prolonged and elastic parliamentary inquiry.
Thank you for talking to us. Qubudile Dyantyi is the chairperson of the committee that will conduct an inquiry into the fitness of Public Protector Busisiwe Mkhwebane to hold office. And the committee yesterday kick-started the process by adopting a draft program that will be followed as the inquiry kicks off. Let me